Welcome. I'm John Davison, CEO of the Trust. Thank you for joining us today for the next webinar in our SPTA Executive Directors and Leadership webinar series titled Legal and Risk Management Considerations for SPTAs. The Trust has long been a supporter of state associations, and we believe that by supporting you, we support our policyholders and that our partnership allows for the most benefit for all of us. As many of you know, we've instituted the Trust SPTA endorsement program many years ago, and we're proud to say that we are endorsed by 48 SPTAs. The Trust is always considering new ways we can be a useful resource for you and for your members. And in late 2018, we created the Trust SPTA Advisory Council. The focus of this advisory council has been to brainstorm ways to enhance the mutually beneficial relationship of the Trust and SPTAs organizationally and financially. The current advisory council consists of the following SPTA executive directors: Dr. Ray Fallon, Hawaii; Mr. Ladarian Ammons, Mississippi; Ms. Carmen Scare, Nebraska; Ms. Martha Turner Quest, North Carolina; and Mr. Dustin McKee, Ohio. Today's webinar is the result of the great work of this group. Now, if you go back one, now I'd like to tell you about our knowledgeable presenters, Dr. Dan Taub and Mr. Steve Benson. Dr. Taub is a clinical psychologist and educator with JD level legal training. He is a professor emeritus at the California School of Professional Psychology, and his areas of professional focus include ethical and legal issues in professional practice, child protection, and addictions. Dr. Taub regularly consults with a wide range of practitioners and community agencies regarding standards of practice and ethical concerns. He's a trust risk management consultant and has been in private practice for over 30 years. Mr. Benson is an attorney at Whiteford, Taylor, and Preston, LLP, and is a partner in the firm's nonprofit organizations and associations practice group. He has nearly 35 years of experience working with nonprofit and tax-exempt organizations on a wide range of legal matters, including governance, tax, corporate matters, contracts, employment, intellectual property, antitrust, and certification issues. Mr. Benson currently represents a diverse group of charitable, scientific, professional, membership, and trade associations and their supporting organizations. Prior to entering private legal practice, he served 4 years on active duty in the Navy in the Judge Advocate General's Corps. Mr. Benson holds a Juris Doctor degree from George Washington University and an undergraduate degree from the University of Massachusetts in Amherst. We're very fortunate to have both of them take the time to be with us today and share their experience with us. I have a few more things before we begin. If you happen to run into any issues, please email seminars@trustinsurance.com. If you'd like to submit a question, please click on the Q&A icon at the bottom of your screen. We'll do our best to answer as many questions as possible towards the end of the presentation. Also, a link to this PDF of this presentation was included in your registration reminder email. If you haven't been able to download this yet, we'll place a direct link in the chat box now. I hope you all learned a lot over the next 2 hours, and I want to welcome again Dr. Taub and Mr. Benson. We appreciate you being here.
Pleasure to be here.
Thank you, John, and good afternoon, folks. Dan and I will trade off during the presentation this afternoon, and we want to make sure that we leave time for questions at the end. I know that you, as a group, had some specific topics that you wanted us to cover, and hopefully the presentation will address most of those issues. But I'm sure that you will have additional areas and questions that you want covered. So make sure that you can get any of your questions into I think it's the Q&A icon at the bottom of the screen. And so we can address those at the end. So on this slide, you'll see our legal disclaimer. I use this in a lot of my presentations. It's just kind of standard procedure for these types of presentations, just to make sure that we're not providing legal advice, but rather we're here to provide general advice for your information, just to get you information and not have any kind of a legal representation issue here. So just a standard disclaimer. I also should have added and included on the screen that we are also not here to provide legal advice on APA-related matters, APA policies, practices, or politics. So that's not the intent, and you would need to turn elsewhere for that type of advice. One caveat to that, as I believe Dan will touch on some APA code of ethics issues during his part of the presentation, but otherwise we will not get really involved in too much specific APA related issues. We're going to start off the presentation. I'm going to give an overview of the basic nonprofit issues, principles, guidelines that would impact most of the nonprofit organizations at some point or another. Many of these items and areas will be applicable to the things that the SPTAs are involved in, and it'll be a little bit of broad brush on some areas impacting nonprofit organizations. What I try to do sometimes is try to educate people on the nonprofit community. I've been working in the nonprofit community for going on 40 years now. A lot has changed during that time period as the law around nonprofits has evolved. But what I really tried to start with is trying to educate folks on about the nonprofit community, and that begins kind of focusing on some statistics about the nonprofit industry. And since you as the SPTA representative, you're all part of the nonprofit industry, I think it's important that you understand the depth and breadth and magnitude of the nonprofit industry. Most people, even those who work in the nonprofit world each and every day, they don't appreciate how large and how extensive the nonprofit industry is. As the information on this slide reveals, there are over 2 million nonprofit organizations comprised of almost 13 million employees, so very large workforce. And it accounts for at least 10% of the nation's private workforce. DC, as you might suspect, has a large presence of nonprofit employment, and over 25% of the private workforce in DC is somehow tied into the nonprofit community. We've also had rather rapid growth in nonprofits in recent years. So it underscores how important the nonprofit community is to our industry. Again, hitting on issue on this slide, focusing again on the information and statistics about the nonprofit industry, we again see the size and magnitude of the nonprofit community. In fact, they're the third largest private workforce behind only retail and manufacturing, which if we gave you a quiz, you probably couldn't have come up with that answer. And the third largest employee payroll behind only manufacturing and scientific services. So again, I try to underscore that you are working in a very, very large community and that does a lot of good with its nonprofit mission, but also has a very significant impact on our economy. So you think that you're in this little part of the nonprofit world, but you're really part of a substantial size and influence industry. And so you should keep that in mind as context as you work within the nonprofit community of how significant its impact has on our economy. On this slide and next slide, we get in a little bit about the overall legal structure that nonprofits have, and then the documents that govern your organization from a governance perspective. And it flows and starts with the Articles of Incorporation. And this is a state-specific filing, and it's on record with your individual state where you're incorporated. So those are all public records in whatever jurisdiction you're incorporated. If you want to change the Articles of Incorporation, you would have to do another filing with your state entity to make that legal change. Flowing down from the Articles of Incorporation, you have your bylaws. This is an internal document that's not usually filed with the state. but it provides some specifics on the governance of the organization. And that document, the bylaws, while not filed with the state, must be in compliance with your state laws and requirements. And then flowing down from the bylaws, you would have your policies and procedures that all organizations have, and that provides and gives you more concrete form to the governance structure. And again, the bylaws and procedures, they must be compliant with state law as well. And then all of these must be aligned so the organization stays legal. However, the only one that's typically filed with the state is the Articles of Incorporation. But it's important and key to make sure the alignment stacks up, because I have groups that I work with, they say, well, this is the way we've always done things, or this is the way we usually do things. And historically, that's the way it's done. Well, you have a legal issue or a problem if you do not have that alignment set up there so that all those documents are in compliance with state law. If you're not aligned, despite the fact you've been doing this that way for however long it's been, you would need to take a focus on those policies, procedures, bylaws, whatever it might be, and you should do a regular review of those documents to make sure that not only are they governing your organization the way you want to be governed, but it aligns up with your state law requirements. So that's a good governance practice to systematically, on a periodic, regular basis, make sure, because the laws and requirements in each state change on a regular basis. So make sure you have that alignment in place as much as you can. Again, I mentioned state law provides the rules for corporations, and that includes nonprofits, and they take precedent over your governing documents. So, like I said, if your governing documents, those four things I just mentioned, aren't in compliance with state law, the state law still controls your organization. So you have to make sure that you get that alignment in place. Articles of incorporation, required filings with the state, bylaws, really a contract with members as to how you want to focus on the government structure and procedures, and again, regulated by state law. And policies, procedures are normally adopted by your board, and they're more flexible, more detailed, but they also need to be consistent with your state law. As far as legal duties that nonprofit organizations face, all nonprofits, there's a duty of care, duty of loyalty, and a duty of obedience. And the duty of loyalty requires you to have an undivided allegiance to the organization and protect the best interest of the group. The duty of care requires that you have due diligence in decision making and making sure that your actions and decisions are on an informed basis. And then the duty of obedience requires compliance with your governing documents. Again, going back to that alignment to your governance documents, you make sure that whatever's in there, you're obeying with that and it's in compliance with state law. We get into some more definition here around the three basic duties that are owed to an organization. On the duty of loyalty, you should only act in the best interest of the organization. No use of the organization's assets for inappropriate purposes. You shouldn't have any conflict of interest. It's not illegal or improper to have a conflict of interest, but how you handle that determines whether or not you have legal issues with the organization. So make sure that you handle conflicts of interest in an appropriate way, even if most of the time it's just an appearance of a conflict. But anyway, you need to make sure you have processes and procedures in place so you can handle any conflicts of interest that may come across the organization. And no disclosure of confidential or proprietary information, and nothing that is not in the best interest of the organization. On the duty of care, I will call out there the business judgment rule, which protects an organization's board and staff from personal liability exposure when acting in accordance with their duties, making sure that you get the information, and when getting the information and then making an informed decision. This doesn't require that the decision turn out to be right. It just means that if you do your due diligence and come to a reasonable conclusion and make an informed decision, even if it turns out that that decision was wrong, you are protected by the fact that the business judgment rule says that you fulfill your duty of care to make an informed decision based on the facts at hand. So, the nonprofit principles here, again, this is focused on federal tax exemption. If you are a nonprofit incorporated in a state, that does not mean that you're a federally recognized tax exempt entity. So you have to not only file in the state to become incorporated, then you must also file an IRS form to make sure that you get recognized on a federal level for income tax exemption. And then most states will flow down your federal tax exemption to the state level, so then you'll be exempt from both federal and state tax. I would imagine that most of you fall within the 501c6 tax exempt classification. That applies to trade and professional organizations, associations which typically serve a particular industry or trade or profession. An advantage of a 501c6 status is that you have the ability to do unlimited lobbying. On the other hand, contributions to a 501c6 organization are not deductible as charitable donations. They may be in whole and part deductible as a business expense for you, but there are some rules around non-deductibility as well there. So you have to be careful about what you do as far as deducting contributions to a 501c6 organization. Another factor that impacts upon nonprofit organizations and you need to be aware of is what's called unrelated business income tax, or UBIT, as it's known as. So revenues and profits from engaging in tax-exempt mission activities are not taxable. And many nonprofits make large profits on which they're not taxed, because the revenues relate to the nonprofit mission. On the other hand, if the nonprofit organization engages in an unrelated business activity that is regularly carried on, then it will be subject to UBIT tax on any net profit. You get a break here, since you are allowed to offset any revenue with any expenses incurred in conducting the unrelated business activity. So you'll only be taxed on the net profit. Also, the law recognizes certain revenues produced as non-taxable passive income, which would not be taxable, even though it is not technically mission-driven, and those categories would include such things as passive income activities would be dividends, interest, and royalties. Those would be non-tax passive income revenue. And let's focusing on a moment on corporate sponsorship revenue versus advertising revenue. You have to make sure that you are aware that corporate sponsorship revenue, which would support one of the mission activities, what mission purposes, would generally be tax exempt revenue, versus if you have advertising revenue in, say, your journals or other places, that generally is taxable UBIT, unrelated business income. So you would have to differentiate between what you have for sponsorship revenue versus advertising revenue. And if, in fact, the nonprofit does receive any unrelated business income, the IRS requires you to look at the gross amount, not the net amount. They'll tax you on the net amount. They look at the gross amount to determine whether or not you need to file an additional annual form. So if you have $1,000 or more gross income from an unrelated business activity, then you must file a Form 990P. And then that the Form 990T is in addition to the obligation to file the annual federal income tax return, which is one of the Form 990s. So each organization must file both the 990T if they have UBIT, and they must file the Form 990 as a general course each year. In fact, as the slide indicates here, there are many thousands of exempt organizations that have to file a Form 990T, but they end up not paying any taxes because the expenses related to the activity offset the revenue. So it becomes a non-taxable event based on that, but they still have to file the Form 990T. Now, switching over to antitrust considerations, nonprofit organizations should have in place an antitrust policy or guideline. Now, with the new administration coming on next month, there probably will be much less focus on antitrust matters. But we still view it as good governance practice to have an antitrust policy in place. And a particular focus could be in policies and procedures for all membership-related, board-related, committee, and other governance-related meetings of the organization and other activities engaged in by the organization. So you should have just in general antitrust policy. And one of the things we say as far as the meetings go, you should follow a formal pre-approved agenda and make sure that the agenda is provided to each attendee. So participants would strictly adhere to an agenda for those meetings. That gives you the guardrails to prevent you from wanting or getting engaged in any type of antitrust behavior. Here's some more information on this slide about antitrust activities and things to avoid in your activities, such as not having members and others come to certain understandings or making agreements related to prices, dividing up markets, or encouraging boycotts of certain markets. Basically, the underpinning should be that each member should be making its own business decisions without consultation with, influence from, or input from competitors. Again, one more slide on antitrust. I think we've hit on most of these: boycotts, price fixing. So. And now switching over to communications or media policies. I think you asked about those types of policies. We again recommend that organizations should have in place an effective written communications media policy. This policy should focus on consistency in communicating the organization's key messages, maximizing exposure, and ensuring compliance with legal guidelines. We suggest you have a designated spokesperson so that when inquiries come in from the public or from third parties, that you have a designated way for communicating the association's position, and that's usually done through either one office or one individual. So you have a central spot for information to be disseminated. And so we also want you to make sure that your organization would have a rule that in general, employees, volunteers, and members should never be speaking about the organization or its policies in any official capacity. You should do that. Bottom line, you should have a written formal process in place that would direct and dictate how communications and media inquiries are handled. Many of you have heard of what's called Sarbanes-Oxley legislation. That generally applies to the for-profit community and public companies. It grew out of the scandals of 20 years ago, some of the accounting and corporate scandals. Like it says here, the law's purpose is to build back public trust in the corporate sector, and it required certain significant new governance standards and oversight of financial transactions and auditing. What many nonprofit organizations don't realize is that that legislation does apply to nonprofit entities in two ways. There are two provisions of Sarbanes-Oxley that apply to all entities, profit and nonprofit, and those two provisions are the nonprofit organizations need to have a written whistleblower policy in place that provides protections for whistleblowers and prohibits certain actions taken in retaliation against those who report suspected illegal activities. And also, nonprofits need to have a written mandatory document retention policy in effect. So those two areas are required for nonprofits. As far as copyright matters go, all nonprofits should be aware of corporate matters, copyright matters. I mean, the definition there is in the first bullet item. Copyright protection subsists in original works of authorship fixed in any tangible medium of expression. You get copyrights that are accrued on when you create a work, and there's no notice or registration that requires to acquire the copyright interest. So you get copyright rights on creation. Now, often this comes up when you're engaging a writer or a consultant to develop content for the organization. So you need to be diligent in addressing, who owns the content and who has the right to use that content. There is a thing called the work for hire doctrine, and typically that means if you engage somebody to create content for you, you would own that content. However, there are exceptions to that, and so what we urge all nonprofit organizations to do is when you're engaging a consultant or a writer to create content for you, make sure you have an agreement in place that dictates ownership, use, and copyright information. So it's really imperative that you have that agreement in place so that there's no misunderstanding as to who owns the copyright at the end of the day. And so one of the other things we do, although the copyright notice on materials that you create or that you use is not required for ownership, we do urge nonprofit groups to put a copyright notice on the materials that are created. And it consists of those symbols there: copyright, year of first publication, name, original. This would eliminate that kind of an innocent infringement defense that somebody might post because they weren't aware that the information was copyright. So we suggest that you go ahead and make sure you put that information, that copyright notice, on the material. And in the copyright arena, also, there's something called the fair use doctrine. The fair use doctrine is codified under Section 107 of the Copyright Act. Fair use doctrine basically is a legal defense to copyright infringement and allows the use of a copyrighted work without infringement if in these certain areas, such as for criticism and comment and news reporting and scholarship and research. If you're using copyrighted materials in those areas, you might have yourself a fair use argument that would eliminate any copyright infringement. The problem in this area is that there's a 4-factor test, but it's vague and subjective, and there's been a lot of litigation around what constitutes and what doesn't constitute fair use. And if you look at the 4 factors there, they are very subjective: purpose and character of the use, nature of the copyrighted work, amount that is copyright, the work that is taken, and the effect on the market. So any particular judge can interpret one of those factors more significantly than other factors, and it could sway the decision as to whether or not it's fair use or not. So the bottom line for us is when you want to use copyrighted information, and you think it, even though you might think it's a fair use, when in doubt, we say seek written permission and consent to use that in some kind of a licensing form, so that you know that you then have the legal right to use that information in the way that you want to use it. As in addition to copyright, we also have trademark issues. Again, we advocate that that organizations be aware of trademark matters, and they're in this area. There are not only trademarks, there's trademarks, service marks, and certification marks that all can be protected. And while registration in the U.S. Patent and Trademark Office is not mandated, we generally advise that organizations should protect their mark through some type of trademark registration and licensing the use of content. So this allows, if you register the trademark or the service mark or the certification mark, that would allow you, the organization, to sue in federal court to enforce registered trademarks, which is typically the preferred jurisdiction. However, if you have unregistered trademarks and you think they're being infringed, you can still go to state court to enforce those trademarks. But we tend to come down on the side of when in doubt, register those trademarks and eliminate the doubt. As with copyright notices, we suggest that organizations, nonprofit groups put a trademark notice on all those things that they feel that are trademark, whether registered or unregistered. So you use TM symbol for unregistered trademark, SM for unregistered service mark, and then the R is used for federally registered mark. So depending upon where you are in the registration process, you should be using one of those symbols. And typically, trademarks are usually around names, acronyms, designs, logos and taglines. So you want to make sure that you trademark those items, and then have a licensing policy in place that would allow others to use, but under your terms, so that you dictate the terms of how they might use your trademark materials. Now we're going to switch over to Dan.
Thanks, Steve. Really useful information. It's going to take a moment for this to switch, but while we're giving the technology a moment to catch up, I'm going to be shifting gears and talking to you a little bit about this afternoon about how the Americans with Disabilities Act may or may not impact professional associations, and especially some of the risk management considerations in regards to the ADA. The ADA actually any longer, that's the most common name. That's what you hear everywhere. But there was a series of amendments that were made that strengthened the act almost 20 years after it was first passed in 1990 and 2009. And it's actually called the ADAAA. So I will go with the shorthand rather than the ADAAA. Okay, so let's see here. Looks like I'm good to go. And Karen, have you given me? You did. Wonderful. Thank you. So I'll start out by talking just about overarching basics, what it is, some of the definitions, and then issues regarding whether it applies to private associations, which are SPTAs for the most part. And then I'm going to go into some specific questions that the committee asked that I think are really good ones about whether they're required to permit emotional support animals. And also, what about trigger warnings? One of the things that state psych associations do and do very well is you often put on trainings, and you may combine 2 or 3 of the associations to put on trainings, for example, about remote care. And then the question, if there's going to be some very difficult or painful material that's presented in that particular presentation, are trigger warnings required, and are they required under the ADA? Okay, so right, a bit pokey here, but let's go. There we go. The Americans with Disabilities Act has 5 titles in it. Okay, there are 5 titles, and the Titles, some of them are not going to apply. Three may have relevance for state psych associations. Title I requires any kind of organization across the board with 15 or more employees to provide reasonable accommodations to employees under the ADA. Some states, California being one of them, has shrunk that number and basically requires compliance if you have 5 or more employees. Now, I know for many of the folks here, you don't have 5 or more employees, so that may not be a problem. But if you do, you got to take a look at your particular jurisdiction, your particular state, and determine whether the ADA is going to apply. But if the state doesn't have any stricter laws, the minimum for application of the employment aspect, Title I, is 15. So if you have 12, you're not required to abide by ADA. There are some good reasons to do so, and I'll talk about those in a little bit, but for the most part, it's not going to be a legal requirement. Title III has to do with when any kind of business, private business, offers services or products to the public, okay? And that includes everything from the hotels and conference centers that most of us know that we use when we're doing presentations to individual healthcare providers. So as a psychologist who has a very modest sized practice, I also have to offer public accommodations. It doesn't matter that I'm a sole practitioner. What matters is, do I offer services to the public? And I do, okay? Now, usually when private associations are in existence, they don't offer services to the public. In other words, they might be a trade association where it's a meeting of, a group of physicists, for example. But for psychology associations, it's possible that you might provide services to the public. And I'll give you some examples of that in just a few moments. Now, Title V is a miscellaneous section, and Title V relates to not retaliating against people with disabilities who are attempting to assert their rights, nor engaging in any coercion. Okay, so especially Titles III and V are going to apply. Title I possibly to the employment situations. Okay, and Titles I and V essentially are going to regulate bigger organizations, right? Titles III and IV relate to psychologists, private practices, clinics, agencies, and then potentially activities of professionals who are members, depending on what their activities are in the actual organization. And then, as I mentioned, if you offer any kind of services to the public. So one thing that's happened with some psych associations across the states is that you may have a Find a Psychologist website, right? Or you may offer trainings to the public. If that happens, then it creates a greater likelihood that Title III will apply. Okay, so keep that in mind. I'll go do both here and start on the left to begin with. It just again around general issues, the definitions for our purposes of understanding the Americans with Disabilities Act is that a person with a disability who would be protected under this act is someone with a physical or mental impairment that limits one or more major life activities in a substantial way. So it is not enough that, say, I'm diagnosed with an anxiety disorder if it's not limiting me in one or more major life activities like going to work or being able to engage in going out of the house. In that case, then it would be considered a disability. So it's important to make the distinction for psychologists, but also just in general, that someone doesn't have a disability simply because they have a medical or psychological diagnosis. Now, if you have a large organization, again, I understand this is not very common, 15 employees or more, if the disability isn't obvious, an employer can ask for medical documentation to confirm that there's a need for what's called a reasonable accommodation. Okay, so essentially within employment and educational environments, the Americans with Disabilities Act requires that we make reasonable accommodations, and also that we, when we're doing public kinds of services or selling goods, that we have accommodations for folks with disabilities so they can access those services. In a nutshell, that's really the core of what the ADA is about. Now, reasonable accommodations in the context of employment, and that term is, what's interesting is that it's kind of grown in terms of the public perception. Reasonable accommodations from kind of a stricter interpretation, and what the law says is a reasonable accommodation is something that has to do with employment or education, whereas the public accommodation is the other term, or public accessibility. But just to define what I mean by reasonable accommodation, it's any change to a hiring or educational process, to a job, the way the job is done, what the environment's like, so that it allows a person with disability who has the requisite qualifications to perform the essential services in the job or functions of the job, and to enjoy equal access to employment of all kinds, okay? Now, accommodations and also accessibility is considered reasonable if they don't create an undue hardship, or if they don't threaten someone, like, for example, a very unruly dog that someone says is a trained service animal that is lunging and biting at people. That would not be considered a reasonable accommodation. Now, importantly, while an employer or an educational institution can ask for documentation of a person's diagnosis or disability, public accommodations cannot. In other words, if we're offering through my state psych association a training process or something on our website, and somebody says, I am a person with a disability and I need an accommodation, we can't ask for documentation. When you walk into the local grocery store or into your local Walmarts and say, well, I'm a person using a wheelchair, they can't ask you for documentation about whether it's legitimate or not legitimate, okay? So there are limitations on the context within which you can ask, okay? Now, in terms of public accommodations, those components of state psych associations where we're offering services to the public at large, not just to members, okay, have to be what's called readily achievable. I think of this as being kind of a parallel idea to the idea of a reasonable accommodation. Readily achievable is kind of reasonable costs, and I'll explain what that means in a little bit, but it constitutes things like having effective means of communication. Okay, so if we're hosting a presentation to the public about trauma or about a recent weather disaster, and psychology associations are moving in to help, and we're doing something with the public, we want to have interpreters so people with hearing impairments can understand what's being described. How and where we present our publicly offered materials would require that we give accessibility to people with disabilities. Permitting service animals. Now, I'm going to make a distinction here. Service animal is not the same as an emotional support animal. We'll get into detail about that in a moment. Physical accessibility, wider doors, removing barriers, like, for example, if you've got stairs and you need to have a ramp, that sort of thing. And then accessible parking, as well as places to stay. Now, the idea of what is readily achievable, similar to the idea of something that is not, is not either harmful or unduly burdensome, but the definition is that it's easily accomplished without great difficulty or exorbitant expense, okay? So what is readily achievable for a small state psych association with 3 employees and presenting something to the public, it's going to be really different than the largest of the organizations in terms of what would be considered readily achievable. So the organization, its budget, and the cost and complexity of modifications are what one considers. And that also the Department of Justice considers if there's a complaint. Did we make attempts to accomplish something? And is it relatively easy? And is it not exorbitant? Now, this has to do with our overall income, and this comes up in many circumstances for state psych associations. I worked in an educational institution or university for almost 3 decades, and one of the issues that comes up is, well, if a student pays tuition, let's say the tuition is for a particular course of education is, just for simplicity, $1,000, but they're a deaf student. Well, we should only be required to spend a reasonable amount. Well, that's not the judgment. And that's not how the DOJ or the ADA contemplates. It's going to be the overall income. So if the institution makes $250,000 a year with income from students, then a readily achievable accommodation would be likely hiring interpreters for that student, even if it might come to something that's significantly more than the actual tuition that's paid by the student. And same goes for an individual, for example, who might come to our presentations, and it's essentially, a public offering. Now, a footnote about public offerings, when you have a private association offering things only to members of the association, again, then the ADA probably would not apply to that. But if it's offering materials and education to the universe of psychologists, either in the country or in the state, there's a better argument that it's more public. So that's again why I think that one could make a good argument that the ADA can apply to state psych associations under certain circumstances. Okay. Let's see. And so also it's about, this is repeating, I'm not sure why. Okay, I'll go on to the next one. Here we go. Just to give you some examples, ranging from what would happen in a particular practice to what an organization might provide in it. This could be a range. Having, for example, for psychologists, shifting around their schedules so a patient with significant social anxiety could come early in the morning and noise and other people's presence would be minimal. Okay, allowing a companion to help a person with mobility disabilities come into a physician's office or even a mental health provider's office, allowing some assistance in completing paperwork for somebody with a brain injury, additional time for someone who has an intellectual disability, allowing, of course, we're required to allow service dogs who might, for example, be assisting their handler, which is what the person who's the owner is called, if they've got a seizure disorder, even if it's not related at all to the mental health services they're getting. And then, of course, ramps and doorways. So, remember that small businesses must comply with Title III when there's an offering to the public. So the list that you see on your left and the one that I just showed you in the fly-in, those would apply to even solo practitioners, right? And when our colleagues ask, does it apply to me? Usually the answer is, yeah, it does. Now, there's a whole list here, and Steve was kind enough to mention this before. From a risk management perspective, one of the things we do is we start with our ethical standards and code. And we like to think about, what's the whole underlying assumption that should be made for psychologists. And principle A is probably the best summation of ethics codes, whatever the profession, especially health professions, which is prima non nocere, we do no harm. And then we try to help, beneficence and non-maleficence, okay? We have other very important principles that in order to do no harm and to do good, we try to be fair and just in the provision of our services and our kind of educational content. We respect persons' rights to dignity and to make their own decisions. We do not engage in unfair discrimination. And the standard that is enforceable for psychologists where states adopt the APA ethics code, or where the State Psychological Association requires members to agree to abide by it, is, again, unfair discrimination, but also avoiding harm. This is the enforceable part of prima non nocere, the general principles. Principles are typically not directly enforceable. It's the standards that are enforceable. Okay. So most SPTAs, as I think many people here know, and it's nice to see so many folks who I know well, adopt the APA Ethics Code and require that members agree. And so members in a leadership position are arguably going to be bound by these kinds of principles and standards, okay? Including, we can't discriminate on the basis of disability, okay? So it's important to remember that when we have folks sign on and then they're serving in our organizations, they are volunteering and they're also agreeing to abide by the ethics code. Okay. Now, to bring this from the general to the more specific, let me make sure I'm not running ahead of myself here. Oh, doing fine. How should state psychological associations deal with requests to permit emotional support animals? Well, there are a couple of things to keep in mind. Very importantly, emotional support animals, if you'll see the bullet point to the lower right, emotional support animals do not have access to public accommodations. So it is actually incorrect to say under the relevant law, including the Americans with Disabilities Act, that a person is entitled to have an emotional support animal. There are really only two sets of laws that allow emotional support animals, and one of them is the Fair Housing Act that goes back to the 60s. The other is the Air Carrier Access Act. And emotional support animals have been permitted, a broad range of creatures, as long as they're not physically dangerous. You know, kind of the famous example our own Jeff Youngren uses in one of his articles of the emotional support peacock, that it can be a broad range of animals. And it's where a mental health professional has prescribed that animal due to a psychiatric diagnosis to allow them to, at least historically, ride free on aircraft, not anymore, but ride free on aircraft, or be allowed in housing that's federally funded in part or in whole, that would ordinarily have a no pets policy. Okay, so it refers to travel and housing. Now, there was a pretty significant change in 2020. The Department of Transportation had sent out requests for comment and they modified the law, the regulations, so that you'll probably notice if you've been doing air travel in recent years, that there are many, many fewer emotional support animals and dogs. And that's because now folks have to pay actual fee, like they have to have a seat for the creature unless they can fit it under their seat. And it no longer is free. The companies are allowed to charge and they can keep certain animals out. So the range of creatures, for example, you know, my beloved emotional support boa constrictor is no longer allowed to just ride on my neck when I'm going on United Airlines. I don't know what they're thinking, but I'm joking a little bit there. A service animal is something very different. Okay, a service animal is defined under Title III as an animal that's individually trained to perform tasks for the benefit of a person with a disability, any kind of disability, sensory, mental health, physical, okay? And if you're in housing or transportation, you can ask for documentation. If you, and many of you have probably seen, and I won't go into detail about this, but you've probably seen that there are letters that many of your members get asked to write. And I think that I have a fly in here, but I may not. Nope, apparently not. That basically just speaks to the contents of those letters. But remember, those letters are about travel or housing, okay? They're not about access to public accommodations, all right? And so that actually limits the extent to which an emotional support animal can go into things like a store. We still see lots of people coming into stores and so forth. I shouldn't say lots, but plenty of people coming into stores or other public accommodations with pets. Well, how can that be? All right. There's my fly, and it finally came. This is just some information about what might be required in a letter for the Fair Housing Act. And Interestingly enough, you can't go into a lot of detail and you can't give a specific diagnosis, but you have to acknowledge that there is a diagnosis. It has to be a healthcare provider and that the animal is needed for full use and enjoyment of the housing that the person has. Okay, so let's repeat it, but let's see if I can get it to move ahead. I love technology, except when I don't. So I want to distinguish a service animal from an emotional support animal. If a person wants to access a public meeting place, a conference center where you're doing an annual convention, and they bring a dog, we can't ask them for documentation. Because remember, that's a public accommodation. It's not travel, and it is not a housing. There are only two questions we can ask to determine whether a particular creature is a service animal. Service animals are only allowed to be dogs or, in some circumstances, miniature horses. Turns out miniature horses can be house trained. They are very smart. They can do all kinds of interesting things. We ask them the question, is the animal required for a disability? And if so, what work or task has the animal been trained to perform? And if the person gives you an answer to those questions, we must permit access to that creature. Okay. Now, for employment purposes, and again, I doubt this is going to apply to many of the SPTAs here, but just so you know, if a person wants to bring in their emotional support animal, interestingly enough, not just the service animal, they get to bring the service animal, right? You can still request documentation, and particularly for a service animal. And then you would engage in what's called a negotiation regarding reasonable accommodations, meaning you get to have a series of conversations about what the person would need in order to be able to function at the job and fulfill the essential duties of the job and have access to that employment. It can be requested, the documentation, by an employer, but not by a public accommodation. Okay. So the question about this is, should the SDPAs make services accessible to members with disabilities, even if you don't have to comply, right? You're doing this with members alone. Now, of course, remember that the members themselves and people who are officers who are, elected by members may, under the APA, require to abide by the ethics codes. And when you have somebody showing up for one of your annual meetings, if it's, for example, in person, the question that if it's available to the public and advertised to the public, even if it may be an ESA, an emotional support animal, there are only two questions you can ask. And those are the two that we talked about previously. I do think there are some real benefits with complying with the ADA and the spirit as well as this particulars. ADA compliance attracts and can help retain members. And most professional organizations, that is an ongoing challenge for us. Okay. Second, it helps to develop a community where more people, and hopefully everybody, begins to feel welcome and wants to participate and can increase involvement in the range of association activities rather than only membership, which are essential for state psychological association survival and also being able to be effective within the state. But there are challenges. For example, there may be conflicts, for example, about bringing creatures in, dogs. In this case, it's going to be just dogs or miniature horses, although I've rarely seen a miniature horse brought into a public setting. If other members have a concern or a phobia. When it's a service animal, and you've asked those two questions and the person has given you an answer, we can't exclude that member, assuming that we have to comply with the ADA. It is probably also, more inclusive to not exclude the member because somebody else may have a preference or even an allergy. You seat them far apart, for example. But when a service animal is coming in with a person, it is the handler who's responsible for that animal's control. So you are not prohibited as an organization, for example, that's saying, yes, we will, we of course, allow service animals if it's an uncontrolled animal. The dog barks, growls, lunges, bites, jumps on other people. You can ask that handler to either remove the creature or leave, or both. Okay. And remember that distinction between ESAs and between service animals. So the service animal person comes in and you can only ask them those two questions. Okay. Now, another dimension of the ADA has to do with web pages. And just this April, the DOJ put out regulations governing state and local and federal governmental agencies and requirements for compliance. But interestingly enough, it's the Department of Justice has been interpreting Title III to apply to web pages for businesses open to the public for years. Okay, the ADA has been in place since 1990, so we're talking about probably around 20 or more years. And this would include, if I had a web page, my practice. And to the extent that you offer, again, services to the public, it can affect you as an STA. Now, there are many different components to web page ADA compliance, okay? And the link that I've given you here that you should have in your slides is to the WWW3, it's to the WAI and WCAG organizations that have this long list of really kind of very detailed ways in which one can come into compliance. So I'm just going to give you some examples. Captioning for audio or visual information, or having a text-to-speech translator, having color contrasts that are sufficient, not only mouse navigation, but also keyboard navigation, large text size, okay? And so those are examples of the kinds of ways one can come into a compliance. And again, many organizations, many state psychological associations have members with disabilities. And so having your pages accessible, even if you're a small organization where you can argue that ADA doesn't require it, that accessibility can promote more membership and involvement. What about trigger warnings? I do a lot of trainings around the country and with the trust and also locally here in California, and I've taught for years, and this has been a very hotly debated idea. Are trigger warnings a requirement of the ADA? And as I mentioned at the start, trigger warnings are essentially a forewarning of a participant or a student that there's going to be course content that's coming up that's going to be disturbing or upsetting. Okay. And the intent of these warnings is to allow participants to take steps to protect themselves, maybe not even attend if they feel like it would be too distressing. And the concern is folks who, especially people with trauma experiences, that they not get triggered. For example, if there's going to be grisly material shown in a video clip, or a very explicit discussion of a particular trauma or assault, okay? So theoretically, these kinds of warnings would allow folks to decide how they're going to approach it and would prepare them. Now, there have been some arguments that the ADA blanketly requires trigger warnings. And on the other hand, there are folks who argue that, for example, Bridgeland et al., that, trigger warnings really coddle participants and are even ineffective. But when it comes down to it, even with opponents like the AAUP, the American Association of University Professors, saying it violates freedom of speech, and the fact that it may actually have the contrary impact. Bridgeland's publication, a study just this past year, as well as Hanon, pointed out that it may increase anticipatory anxiety for people who are traumatized. So it's kind of like, good idea, but the actual reality may be that it causes harm. Notwithstanding this debate, these general warnings are not required under the ADA. But if a particular prospective participant is a member of the public or a student of yours and they request it, we're supposed to use them as reasonable accommodations if it's requested. So it's fairly narrow. Somebody actually has to request it, right? Now, even Bridgeland, who published that study that I mentioned that shows that these are not necessarily very helpful, has suggested, among other authors, that even without a specific request or an ADA requirement, it is a way of increasing greater inclusivity and fostering more engagement if we let our participants know and we ask our presenters to inform them if there's going to be disturbing or potentially triggering content. And I encourage each of you to be thinking about that with your leadership, membership, and considering having policies. But just so you know, this is not an ADA requirement. Okay, this is something that is only required when there's a specific request. Okay, I'll stop there and let you take over, Steve.
Well, as we do the technology control transfer, thank you, Dan. I for one didn't know I'd be hearing about peacocks and miniature horses today. So thank you for that information. One of the other things I believe the SPTAs asked for was some information. What are the information requirements around sharing information with the public and also required information disclosure? So that will be the next section of our presentation today. And a little slow on the transfer here.
Yeah. I'm not holding on, Steve, I promise.
Okay. You can tell us more stories about miniature horses.
You know the extent of my knowledge about miniature horses.
Okay. Says I'm in control, but it
there you go.
okay.
Yeah.
All right, as far as information sharing goes, all tax-exempt organizations must make their annual federal income tax returns public and also their tax-exempt applications. So both of those documents, they must make available for public inspection and copying upon request. So in addition, you can get those documents directly from the IRS if somebody wanted as well. And this requirement basically applies to all tax-exempt organizations. The copies must be provided immediately in the case of in-person requests if they come to your office. And then if it's a written request, you must comply within 30 days of the written request. Now, IRS rules do allow you to charge a reasonable copying fee and actual post if it's mail. So for the exempt organization tax return, actually the tax exemption application is the Form 1023 or 1024. You must make that available regardless of whether or not you filed for tax exemption 10, 15, 20 years ago. You still must make that document available for public inspection if requested. And then in addition to that, all nonprofits file the annual return, which is one of the Form 990s, either the long version or the short version, as well as we talked about earlier, the 990 T form, which would be for the UBIT tax filing. So the time period for the annual returns are 3 years. So they can come in and request 3 years worth of annual filings that you must turn over. And it includes basically the entire tax return, all supporting schedules, attachments, and documents. But the one thing that you're not required to disclose are the identity of any contributors to the organization. You can mask that information out. And so that's something to be aware of, because a lot of times people will turn over all their forms without masking or deleting the names of contributors. So it's important that you remember that you are allowed to do that. There is a penalty and fine for a failure to provide the annual documents and returns. So, and it falls on the responsible party. So you individually could be the one that has to pay this fine, and it's a penalty of $20 per day for as long as the failure continues. So this could be a significant a fine that's leveled against the organization, leveled against the individual for failure to provide the annual return. And It does cap out at $10,000, but it's for each phase. So you could have multiple individuals come to your office for the annual returns, and for each phase to provide, you've got a maximum penalty of $10,000. So you must be very careful to comply with these organizations, with these requests, or otherwise face a personal fine. So the federal income tax return, we talked about this, the IRS Form 990. If you file the long form, there's a lot of detailed information in it. It's basically your report card to the public, and it gives the IRS a lot of information about the organization. A number of years ago now, they significantly revised the Form 990 form, and what they did is they added question after question about governance and management issues, and it turned it and very little information, additional information about numbers. So it basically turned the form into an information return versus the numbers return, and it allows the IRS insight into how nonprofit organizations are running their organization and whether or not they're in compliance with their mission and tax exempt status. So you see on here, there's an indication of the questions that the kind of questions that they're asking that can be gleaned from an annual tax return. I will highlight, page 5 through 17 of questions about IRS filings and tax compliance. Those are all questions; they're not finances. And then pages 6 to 20, they ask a number of questions about governance, management, and disclosure. Again, they're asking for information rather than finances. And then the big thing that a lot of people focus on when they look at the 990 tax return, people want to know about compensation information. And you, as the nonprofit organization, must make a public disclosure of compensation paid to board members and key employees. So anybody can come in; it's a public record, and they can go on through guidestar.org and look at the tax return of any nonprofit entity. And a lot of times they're researching what the nonprofit is paying its board as far as compensation goes, and what it's paying its employees. So these information returns are being used for a variety of different ways, both by the government and by the general public. So it's important that you fill out the form properly, and because there'll be a lot of people looking at it. Again, I say for the annual return, just in the governance and management section, they look at how you govern yourself, and they're looking for information on the members, the board members, any relationship issues, management duties, where are they assigned? They're asking if minutes are being taken for board meetings and committee meetings. They're looking for any changes to your governing documents that we talked about earlier. So they want information related to the governance and management. So, and as you check off these boxes, oftentimes you also have to add additional pages of description when you answer the questions in a certain way. In addition, they ask all these questions about policy, and they want to know if you have written policies about conflict of interest. They're asking you if you have the whistleblower protection and the document retention policy that we mentioned are required by Sarbanes-Oxley for all nonprofit organizations. They're asking you, the IRS is asking you, they're putting on record, you have to put on record whether or not you're in compliance by having these policies in effect. So they also want to know about how you're compensating employees, and there's a process that the IRS requires for board members to review the 990 before management submits it to the IRS. So there's a lot of different governance and compliance matters that you have to follow when you're submitting your annual Form 990. A lot of oversight, and then there is information in there about the finances, but it's a lot more limited than it used to be before they changed their requirements. Also, in the area of information disclosure, there is this area of which, unfortunately, if you get involved in litigation, there's document discovery. So there's required information disclosure in this area as well through the discovery process. Nobody likes to get dragged into court, but we do have a litigation-prone society, and the judicial system here in the U.S. is set up to provide for liberal production and examination of documents and other information in preparation for trial. Basically, most non-privileged documents are subject to discovery, and litigants can get a whole lot of information, even if it's not evidence that could be submitted into the court during the trial. They're still entitled to get that information as part of the document discovery process in order to prepare for trial. So even if it's not usable in court, it's most likely usable or in discovery process and disclosed. So you have to be careful that you protect all of your documents that would be privileged. So there is a quote up in here that the discovery provisions are to apply as broadly and liberally as possible. That's according to the U.S. Supreme Court, and most states have adopted similar generous disclosure rules. So, but the good news is that discovery is not unlimited, and there are a few protections, and that usually comes in the form of attorney-client privilege documents and communications, or something that's called work product. And as far as the attorney-client privilege goes, that protects the person's confidential communications with his or her attorney. And there's a 4-factor test to determine what constitutes the attorney-client privilege. And it's very specific. It applies only to communications made between privileged persons, that would be the attorney and the client, that are done in confidence and that are done for the purpose of obtaining legal assistance. And what's important here is that there are some exceptions to it, but what's important is that the privilege belongs to the client, and only the client can waive it. And clients, unfortunately, end up waiving the privilege by doing things inadvertently, like they share their conversations that they have with their attorneys that would be protected by the attorney-client privilege, and they inadvertently share it with others, neighbors, family members, trying to get support for a particular litigation or answer a question about particular litigation. And that's hard. But the fact is, if you need to be very careful in revealing anything outside the privilege, because it can be easily waived by the client, even in an inadvertent situation. I've had people ask me, well, if I'm communicating with person X and I see you as the attorney, that'll protect that communication, will it not? And the answer to that is no, because you didn't fulfill the 4 factors up above that constitutes a privileged communication, because you're not doing that communication in confidence to the lawyer. You're just seeing the lawyer and tagging him into the conversation or communication you have with some third party. So you have to be very careful about who you communicate with and how you can communicate with, or otherwise you may inadvertently waive the attorney-client privilege. Also, the scope of discovery in litigation matters, they're very broad. Basically any non-privileged matter that is relevant to the claim or defense is discoverable, and this includes the existence and description, nature, custody, and location of any document, whether electronic or otherwise. So if you get into litigation, you will get from your attorney a litigation hold letter where they will tell you all the things that you must do to protect and preserve discoverable materials and documents and communications, electronic and otherwise. So you'll get this long letter. It's describing basically you need to not destroy or get rid of any documentation that might relate to that particular matter. So there are a few examples where the judge might restrict discovery in a litigation matter, but that's usually related around duplicative information that's being sought, or or things that are clearly not relevant to the matter at hand. So you have to assume that most everything that you're asked for in discovery will be discoverable unless you go to court and get a judge to rule on one of these limited exceptions. Um, uh, Basically, on this slide, we indicate that again, courts will do not look favorably on trying to narrow the scope of discovery unless it can relate to privileged information. And so the documents and materials and things people ask me all the time, what can they get? They can get almost anything: letters, texts, personal emails, anything that's in the system, whether it's a hard copy or electronic copy. They are permitted access and discovery to that information. Basically, all communications will be discovered. If it can lead to admissible evidence, it will be discovered. So that's the way you should approach any information related to a litigation matter.
Okay. Let's see if the handoff works here, Steve. We'll give it a moment for our
Okay.
technology to catch up with us. It's usually so far ahead of us that this is not a problem. Okay, thank you, Karen. So I'm going to pick up talking about, there we go. Yeah. Oh, why is this? Oops, it's going in the wrong direction here. There we go. I'm going to pick up talking about essentially risk management issues and strategies in a very politically challenging time when there are different laws and different approaches that are significant. I'm going to be using gender affirming care as one exemplar, and that was one of the questions that was asked. I'll touch on the interjurisdictional complexities. I'll probably spend a modest amount of time on that. Our relevant ethical standards for presidents of state psych associations and members and boards of directors, and some steps to consider. Okay, so that's the focus of this portion of the presentation. All right, seemed to work really well a moment ago. There we go. So it's not going to come as a surprise to anyone here that gender affirming care and issues having to do with transgender and gender diverse individuals in the United States have become a very hot topic in our current system. And around 26 states, as of a few days ago, have adopted legislation, especially limiting what's been termed gender affirmative care for youth. And before I go much further in terms of talking about that, I'd like to give you just a little bit of a sense. Many of you may know, but just to kind of bring us all onto the same page of how gender affirming care is defined. Okay. And for psychologists, about 9 years ago, the APA put out a gender affirming or guidelines for practice with transgender and what they called non-binary, gender non-binary. Now the term that's being used is gender diverse people. But the WHO, World Health Organization, has defined gender affirming care as a range of social, psychological, behavioral, and medical potentially interventions that are designed to support and affirm an individual's gender identity when it conflicts with the gender that they were assigned at birth. Okay, and the interventions are intended to align various aspects of a person's life, emotional, interpersonal, biological, with their gender identity. And there's a range of interventions. They fall along a continuum, just as one reads the gender identity literature, the range of gender identities can fall along a continuum. And the American Psychiatric Association points out that it can range from counseling to changes in social expression to medications or even surgery. Okay, a range of interventions that can be used. For kids in particular, children and adolescents, the timing is based on several factors, including the youngster's cognitive and physical development, their emotional and social development, and of course, parental consent. Surgery to transition a person to another gender to, for example, reduce their Adam's apple, it is rarely provided in the United States, or actually almost anywhere, to people under the age of 18. Okay. And as the American Academy of Pediatrics says, that the goal is not to try to push the child into one identity or another. The goal is to listen to the child and build an understanding and create an environment of safety in which emotions and questions and concerns can be explored. Now, having said that, and I'll go back to the slide here, what most states have disallowed at this point are the medical interventions. In fact, that's the predominant approach, and mostly with minors, although there are some states. Missouri, as of November of this year, had a judge determine that legislation to limit gender-affirming care for adults was considered, in that judge's opinion, to be constitutional. I suspect that the ACLU and PFLAG will be appealing that ruling. There's also a ruling and a case in front of the Supreme Court about right now as we speak. I think the oral argument may have been on December 4th for that case, this genetic case. But in any event, there's a lot of legal activity and case activity happening. Most of the limits are around youth. Most of the limits, if not, are predominantly around the medical interventions, the use of hormones, for example. Florida has restricted adults to only getting gender-affirming care when they have in-person informed consent before they can be treated with hormones. And the services have to be overseen by a physician. And 7 states have limited gender-affirming care payments by Medicaid. So they've restricted it and say that gender-affirming care is not paid for by Medicaid. Some states has gone as far as to say, especially with minors, that it's a felony to provide such care. And they ban people from knowingly engaging in the contact that, quote, aids and abets such care. And Florida is an example of a state that has that particular legislation. So for psychologists and for state psychological associations, to the best of my knowledge, there's no psychologists, including psychologists in states that allow for getting licensed to prescribe medications. Those medications do not include HRTs, hormone replacement therapies. So in terms of the actual practice for psychologists, most states don't have direct limitations. Okay, let's see here. Here we go. Well, went beyond where I wanted to go. So this is actually from Erin in the Morning, had been tracking every year the states that had what they termed, what she termed anti-trans legislation. And they are in the dark brown, and kind of tan states. The states that are blue either didn't at that point have a likelihood of passing that legislation. The light blue and the dark blue are the states that are safest, many of which have passed legislation to protect gender affirmative care. You can see kind of a similar cutout here. This is from Amy Harmon's article in the New York Times about what's banned. And you can see that the light ban is surgeries only. Banned in general, meaning that it includes the hormone replacement therapy, are the states with the not light blue, light purple, are the states with the dark purple. Okay, the kind of grayed out states are states that have no such legislation, and Montana and Arkansas had the ban blocked, at least as of about a month and a half ago. This is for minors. Okay. And then kind of a mirror image of the original material. This is a New York Times article. It states legislation on gender affirming care. States of calling themselves sanctuary states, California, Colorado, New Mexico, New York, and Illinois, et cetera. Those are states that are saying that gender affirming care is protected and may even protect professionals from being sued by another or other states trying to prosecute them criminally by protecting them from being extradited. So, again, most of the bans are on gender affirming care to minors, okay? Although there are some, including Missouri and Florida, that are restricting such services to adults. So part of what's happened is that there's an increasing amount of confusion about these laws that have led to a chilling effect, not only on services being provided generally, but even with folks talking about care, which if you have a presenter at, in a state where it is considered illegal to do the medical services, then those presenters are beginning to get much more cautious about engaging in discussions about gender affirming care. And that's the case even in states that don't have what Florida has under, the Florida Senate Bill 254 and their file to 538, when they're basically saying you can't aid and abet that kind of service, which arguably could be a clinician who is providing, that is a mental health clinician, psychologist who's providing gender affirming care. So some states, even though that it got ruled in May of this year in Texas, some states actually have said that directed, and this is Texas in particular, but I believe also Oklahoma, that there are child abuse reporting laws that would apply. So if that care was being provided or and a psychologist knew about it, the family came to them, that they would be mandated to report it as child abuse. This is pretty complicated because for now anyway, that doesn't appear to be legally required even in Texas. I'll go into a little bit more detail about that in a moment. But where you are in your state, what your particular rules are, or states that are distant, where one of your clinicians is a member of SIPAC with a temporary practice permission or an e-passport, if they're working with somebody in another state that is either more restrictive or has different rules than your state, it becomes complicated. And it creates some significant conflicts between your home state laws. Let's say you're in Illinois and your provider is a member of SIPAC and is providing services into Texas. The home state rule and the receiving or state rule are different. And some of those may actually be more restrictive in the receiving state. Patients may come to your state, and those states may be states that have some bans or simply no laws, or may not be sanctuary states, to work with a clinician when they're going back to a state where it's illegal. And unless there are specific protections in your state for those clinicians who do gender affirming care, arguably they could be charged with aiding and abetting. Although it's not easy to get across state jurisdiction, it's possible, right? So one of the main messages that I want to give is that, especially for clinicians who are practicing in SIPAC states who have the SIPAC credentials, where they can work into now 41 other jurisdictions aside from their home state, if you're working in a non-restrictive state into a state that has gender affirming care restrictions, the SIPAC Commission regulations require the professional to abide by the receiving state law. They've been very clear about that. If those state laws have to do with the health and welfare of the citizens of that state, the SIPAC Commission says you have to abide by the laws of the receiving state, meaning Oklahoma or Florida if you're in Illinois or you're in Connecticut. So this can create some ethical dilemmas for professionals, but I don't see it as necessarily creating an ethical dilemma for a state psychological association to offer information or trainings per se, or describing. That's a First Amendment right, okay? The practice issues and actually talking with clients, that's what's become a little bit more vague and difficult to know what's going to happen, especially in states that that limit this kind of care. Now, obviously, and I spoke to this a little while ago, we have very clear ethical standards that many state laws have adopted, state statutes have adopted, but also state psych associations, principles of justice, respecting people's rights and dignity. And you'll notice that it's specific under the APA Ethics Code, that it says that psychologists respect the dignity and worth of all people, the rights of individuals to privacy, confidentiality, and self-determination, and are aware of and respect cultural, individual, and role differences, including gender and gender identity. So very clear in our 2017 ethics provision. And so, in addition, there are enforceable standards. 1.02 is the standard many of you may know about that arose in the context of the intense controversy and distress over psychologists' participation in torture and the allegations regarding that. And 1.02 was modified in 2017 so that if there are conflicts between law and ethics, psychologists make clear our commitment to the ethics code and try to resolve those differences, but under no circumstances may the standard be used to justify or defend violating human rights. And this is where it comes down to kind of a key and very difficult conflict, okay? And we have another enforceable standard, 3.01, that also again says that we do not engage in unfair discrimination, okay? So these principles, these standards, some of which are enforceable in some states, really focus on client and patient autonomy and care and the welfare as a primary consideration for the services that are provided by member psychologists. And so it's become extraordinarily important to track within each of your states, but to let your psychologists know who are practicing into other states that it is their obligation to track policies and laws in the receiving states into which they're working, so that we're not only abiding by the laws in one's own home state, but also the receiving state, and we're acting in keeping with the ethical principles and standards and following appropriate empirically based approaches to care. So one of the things that's been recommended is that within your state, members and associations build alliances with stakeholders as a way of helping to disseminate knowledge, increasing the effectiveness of advocacy around issues related to gender affirming care, and using psychological science to counter misinformation and misleading narratives. And when the rules do not track or laws do not track what is known, to make known what the science says and what practice says. So I've mentioned the guidelines before. It's actually a really helpful document. It's now 9 years old. And for those of you who have members who are working in this area, they're probably very familiar with it. Just this March, the APA put out a consensus statement about using psychological science to combat misinformation and providing a groundwork in some respects for psychologist advocacy regarding access to care. And this March 2024 consensus had a series of 7 recommendations. And to the extent that that members wish to be engaged in this kind of work, and arguably should be engaged in this kind of work, is to not repeat misinformation without including corrections. And I know that sometimes this can be an issue vis-a-vis listservs, and I'll be ending this soon and give you an opportunity, Steve, to talk about listservs and some misbehavior on the part of professionals. But collaborating with social media companies, using social media in the appropriate fashion to help reducing spread of misinformation, using misinformation correction strategies. STPAs don't do counseling, but it can offer skills training, information. Psychologists can be part of helping to set, empirically grounded norms. and leveraging trusted resources to counter misinformation. Also debunking and what's called pre-bunking, which is essentially inoculation, by giving folks information and also helping them think critically about what they read and they hear and they're looking at on social media. And then working with social media companies to get access and transparency regarding scientific research that is supposedly published. Okay, so the risk management issues are primarily that, you know, for those states in where there's no aiding or abetting rules, and that's majority at this point, the risks to clinicians and to training and to hosting, you know, having conferences on this are going to be very low. They're not going to be high. Okay, referring for medical interventions is somewhat higher in the jurisdictions with bans, but mostly they're bans on medical procedures. Okay, not therapy or counseling, so long as what you're doing is not, you know, kind of funneling or you know, demanding that clients go get the procedures. Okay, which that's not what we do in gender affirming care. That's not what we do. If there's a complaint for having a therapeutic conversation with somebody, I think there's a pretty strong First Amendment constitutional argument for freedom of speech. But our primary risks are board complaints, and boards are very conservative creatures. So those defenses, for the most part, haven't been tested as against, you know, what therapists do, and that's not the kind of thing that's going up to the Supreme Court right now. At this point, you know, Doe versus Abbott in Texas, it is not a mandated child abuse report, although it's still a directive for investigation by the Attorney General. But that doesn't mean that psychologists are required to report transgender care, even in Texas, which has had the most kind of forceful legal approach to trying to get put gender affirmative care to a stop for minors. And the biggest risks are interjurisdictional practice into receiving states or from receiving states, many of you are here, from actually home states, many of you here, where there are clear bans. And that's, you know, and then the aiding and abetting issue, and also the kind of maintaining a kind of stance that is not saying you must go, that can get folks in trouble. But again, that's not our usual standard of care. Right. So I'm going to turn this over to you, Steve, to bring us into the home stretch.
Okay, thanks, Dan. So to finish up the presentation, I'm going to cover two areas. First of all, contracts, various contracts that nonprofits will enter into. So that will apply to some of the things that you're doing as SPTAs. And then the second area is addressing some member misconduct issues and how to address them. Again, slow transition.
Yeah.
Okay. As far as the key concept to for any contract, and here we're focusing on some vendor contracts, the key concept is don't accept member contracts as is. Negotiate. Any contract can be negotiated. They're all negotiable. All terms are negotiable. So don't accept the vendor's form contract and sign it as is. Make sure you focus on things that are important to you for that particular vendor and the service that you're looking for. This is some of the key contract provisions that you should look for in vendor contracts. I'll focus on two of them: intellectual property. Make sure that you understand who owns the copyright, who owns the trademark, who owns the confidential information, what kind of personal data protection there is. Make sure that you cover the entire field when it comes to what is to be expected with that vendor contract on intellectual property rights. And the second thing I'll focus on is identification. Make sure that you negotiate the indemnification provision, because you want the vendor to be responsible for their actions and their deliverables, and you don't want to be held with a liability exposure because there's a limited liability provision in there. Now, some vendors will impose an artificial cap on limitation of liability in all their vendor contracts. it's hard to sometimes negotiate around that. In that case, make sure that you have liability and insurance protection to backstop if you have to accept a limited liability provision in a contract. But make sure that you negotiate these terms to get things that are more favorable to the association. As far as hotel contracts go, most of you will at some point in time enter into a hotel contract. Again, don't settle for their form contract because they'll try to stick you with their form contract and have you sign. Again, negotiate. And here are some provisions that you should be focused on. I will focus on one here, and it's a big item right now, and that's force majeure. Force majeure, the hotel industry got slammed from COVID. They were open for business, but groups were canceling because of COVID restrictions and health restrictions. And so they have pushed back. Now that we're post-COVID, the hotel industry is pushing back, and most hotel contracts will have very limited force majeure rights for you as the association. And typically, the only way to get out of their form contract with force majeure is if performance is illegal or impossible. Well, you almost can never get to that trigger. But so, for example, 9/11, FAA shut down air traffic for several days following 9/11. Hotels were open for business, but people couldn't get to the cities and to the hotels. But the hotels could say, well, you could have gone by rail, you could have gone by car, you could have gone by bus. They were open for business. Now, they ended up allowing force majeure cancellations, even though it wasn't impossible or illegal for people to go and travel and get there somehow. They let people off because they would have had a public, relations nightmare in that case. However, they didn't legally have to allow the associations out of those contracts because it was not illegal or impossible for them to perform or for the association to perform. So what we try to build into our hotel contracts are other triggers that will allow force majeure to happen, such as it's inadvisable to perform or it's impractical to perform, unreasonable delays, things that prevent performance. And we always try to throw in a catch-all clause there that says anything that materially impacts or prevents performance would be a trigger. The hotels will fight you hard on those triggers, on those other additional triggers, but that's what you need to be negotiating around because it's going to be very hard for you to try to get out of some of these contracts when something happens and it's not impossible or illegal to perform. So that would be my focus on hotel contracts. And then meeting speaker contracts, again, don't use the speaker agreement form as is. If they give you a form agreement, negotiate on the terms and provisions. You may want to develop your own standard independent contractor form, which would be more compatible and more amenable to you from the association point of view, and be specific about getting things in writing as to what the terms and conditions are. And again, I focus on intellectual property rights. Make sure you indicate who owns that presentation, who owns that speech, who owns the materials that are produced, and have provisions in there about responsibilities of the speaker, indemnification from the speaker. There was a question in the chat about one of the SPTAs got called on the carpet because of a copyright infringement issue from the speaker slide. So the way you handle that is in the speaker contract. You require the speaker to only provide materials that are copyright compliant, that don't infringe on anybody else's rights. And then you have an indemnification provision in there that says that if in fact that the speaker does bring something into the presentation that's a violation of law, violation of copyright, whatever it may be, that the association would then be indemnified by the speaker. And then again, you should have insurance to back up you anyway, because if you're going to get, if there's a problem with the speaker slide, you're going to get sued as well as maybe the speaker, and you may have a deeper pocket than the speaker. So you want to make sure that you have insurance to back up that if that situation arises. Switching over to member misconduct, I know that a lot of associations are concerned about member misconduct issues. What we look at when you're either disciplining or removing a member, make sure you build in substantive and procedural due process into that, so that there's inherent fairness in that process, and the result is something that is fair and reasonable and not arbitrary. So what the process should look like, we put 4 things in there for you to consider. Make sure the person gets notice of the charge against him or her, that person has an opportunity to respond and defend his or herself, that you have somebody that's fair and impartial, that's the decision maker, and at the end have an appeal right to somebody else to take a look at and have a different lens on that. So that would be some of the due process they would build into that. Other organizations use a code of conduct to regulate certain member activity. The code of conduct can apply at all levels of the organization, both staff, governance, members. I've seen it in bylaws. I've seen it as, when you're registering for a meeting, it's a code of conduct in there, and you check the box that you agree to comply with the code of conduct for that meeting. I've seen it included in membership application and renewal process, where they set forth whatever the standard is, and you agree when you check the box or you sign up for that particular activity that you are agreeing to whatever the standard is that your association has put forward. So it's just a way of again regulating member misconduct, focusing on proper conduct, and try to ensure that there is some integrity in that process. Also, we talked a little bit earlier about a kind of a media policy, some kind of a policy about social media, how to use social media, things to consider here, or use disclaimers to protect the association, have rules about what can be posted, what can't be posted, link to any conduct standards. Just make it known how it's going to be monitored, how it's going they can use these things, and then at the end of the day, have the ability to remove any postings that you find to be offensive. So, and then one other thing I've seen that some of the groups I work with, they develop an attestation process to evaluate eligibility of individuals for not only awards and recognition, but to be eligible to sit in the governance position, leadership position. And you can tie that to any kind of conduct you want, whether it's limited to just harassment or intimidation, bullying, other behaviors as well. So you get to decide what that misconduct trigger would be to allow eligibility to receive an award or to be considered for a board position or a committee position. So, and here I just put one example of what that attestation statement could look like. Here the individual is signing off that to their knowledge, they are not been found guilty or pled guilty or done anything related to harassment, intimidation, or abuse of power. And they've not settled any such matters, and they're further attesting they've never been punished. So you can use these types of attestation statements as a way of being a screening tool for eligibility for awards and board positions. And we found that to be a good tool. It eliminates some people that you probably, you wouldn't want given an award to, or you wouldn't want to give any board or committee seat to. So that's something to consider as in this area of member misconduct as well. That comes to the end of our presentation, and so I know I addressed one question in the Q&A section on speaker contracts, and the other question that related to the materials that I provided was related to the attorney-client privilege. And the question was, if the CEO meets with the attorney on behalf of the organization on an issue, can the CEO report back to the board of directors on the advice given by the attorney? And so the general answer is yes. the CEO is representing the organization on behalf of the organization with getting that privileged communication from the attorney. The board of directors is a legal representative of the organization, so the CEO can report back to the board on those matters. However, you must be sure that there's no guests in the meeting room when the CEO is reporting back to the board, because that could waive the privilege because you have a non-board member that would be receiving the information from the CEO. So make sure that there's no uninvited guests or unintended guests in there. And also, if you're at all concerned about the attorney-client privilege in that situation, make sure that the attorney is available either in person or on the phone so that they can continue the discussion in the context of the attorney-client privilege between the board, CEO, and the attorney. And Dan, I don't know if you can see the questions. I think there are a couple for you.
Yeah, I see that there was one question about, are we liable if we're not made aware of a disability? For example, someone who is using a wheelchair attends an event, but we're not made aware ahead of time and parts of the venue are not accessible. Can they retaliate? Arguably, they can, because remember, if it's going to be something offered to the public, and I'm going to, in kind of a little bit edge into your territory, Steve, I'm going to use a very legalistic idea, which is it really depends. If you're presenting it to the public, then a reasonably accessible place is what's required. So if that's the case, and there's larger than just one's membership who've been invited, then I would make sure that you have routinely you're checking out the venues for accessibility throughout. And because so many, whether it's Cody or New York City or in Honolulu, any kind of public accommodation needs to be in compliance. So you can get some on you and you can have some potential liability if you don't choose places that are accessible. It's also not a bad idea to routinely request and ask for people to request if there's some special need or accommodation, so that you can decide exactly what you can provide and what you can't. They don't have to give you any documentation. They just have to be able to, if they're bringing in an animal, answer 2 questions. If they're not, they can ask for an accommodation, okay, and request that. But for the most part, it's not a bad idea to choose places that are going to be able to support access by members for pragmatic reasons as well. Steve, did you want to weigh in on that or?
No, that's good.
Okay, great. And then the other one, hey, Chuck, nice to see you. Yeah, this has been happening recently. I did not comment on this, but I did mention the Missouri case has gone up to the Supreme Court. But the AG in Missouri, as you point out, has been sending letters out to psychologists he discovered have provided services to transgender patients, generally kids, and he sent letters in 3 states, not just to Missouri, and it has caused organizations to stop services. So this is that chilling effect that I was talking about, but in a very major way. It's, the AG writes you a letter, it's hard to ignore it, On the other hand, this is very clearly, in my view, a First Amendment right, talking about the kind of care that is available, whether it's in a state or not. It's going to be, I think even our current Supreme Court might agree that limits on the discussions in counseling shouldn't be there. The problem is, Chuck, and this is true for anyone in states like Missouri, that that's going to mean going into court. And it's going to mean battling this. And there was, as some of you may well know, the psychologist who stepped forward with permission of the family in Texas joined as one of the plaintiffs in Doe versus Abbott. And I think it was Dr. Morris, and the plaintiffs prevailed. But it's gone through a very long process. We're talking about 2 years of litigation and going back down from the Supreme Court to an appellate court. So this will involve litigation at some point, and there aren't any guarantees about the result. But that being said, it's exactly the chilling effect that you're describing that is concerning. But remember that training or teaching is a very different activity than providing services that are medically related. So, to the extent that Missouri AG is taking the perspective that you're aiding and abetting, or I am, if I'm providing care to a youngster that is gender affirmative, then they could have me in their sights. And I think that's why many folks have said, okay, I'm not going to do this. So yeah, I'm aware of some of the AG's actions, and in some states where they have, essentially are providing protections, I guess like Washington State, for example, and in California. Basically, they're saying if you're practicing into this other state and you're doing that service, we're not going to let them get access to you if they want to extradite you from the state. It's great unless you actually have family in Missouri and you want to visit, and you're not going to be visiting with them. So I'll stop there. I think we're just about out of time, John.
Well, thank you, Dr. Taub and Mr. Benson, for such an informative webinar. I learned a lot. Just to remind folks, this webinar was recorded, so it can be referenced later. Please contact your SPTA liaison, Karen Green, at Karen Green, that's with an E at the end, Karen.Green at trustedinsurance.com if you'd like access. And please note that our previous SPTA webinars are available on our SPTA endorsement page, which is located under the About tab at www.trustedinsurance.com. So this includes our two-part series on marketing and our introduction to directors and officers liability insurance, also known as D&O. And finally, if you have ideas for future topics or on ways that we can continue to support you, please reach out to us. We'd love to hear from you. Thank you again for joining us, and thanks again to our speakers, and everyone have a great rest of your day.
Thank you.
Thank you.